Ayan, okay na. Sige, so I've discussed earlier the general rule. Okay? When the ownership is not yet transferred to the buyer, meaning the ownership is still with the seller, therefore the risk will follow the owner or the seller. But when the ownership is transferred to the buyer, the risk will also follow the buyer, who is now the owner. That is the general rule. There are exceptions, however. The first one is unless there is a contrary agreement or unless otherwise agreed upon by both the parties. Okay? And the second one is ayan, pasensya guys, may kumakain sa tabi ko kanina, pinaalis ko lang. Sorry. The second one is where the delivery of goods has been made to the buyer. When we say there is delivery of the goods to the buyer, meaning when we say there is delivery, there is a transfer of ownership from the seller to the buyer. Therefore, generally, we apply the rule above, di ba? So, the owner is the buyer. Okay, therefore, the risk will follow the buyer. Pero ang sabi niya dito, in pursuance of the contract and the ownership of the goods has been retained by the seller merely to secure performance by the buyer of his obligations under the contract. The goods are at the buyer's risk from the time of such delivery. Okay? Meaning, even if ownership has already been transferred, okay, there can be an agreement between the buyer and the seller that the seller may retain the goods not as an owner. Okay, the seller will retain the goods not as an owner, but merely to secure performance by the buyer of his obligations. Kumbaga, para lang gawin ni buyer yung part niya. Kasi ikaw, as seller, ginawa mo na. Kasi dineliver mo na yung goods. Okay? There's already the transfer of the ownership. Okay? But they may agree that the seller may retain the goods, okay, to secure the performance by the buyer of his obligations. The third one is where actual delivery has been delayed through the fault of either the buyer or the seller, the goods are at the risk of the party in fault. Okay? Just like in your obligations and contracts, di ba? You have discussed there the meaning of delay, instances wherein there could be delay. Okay? Di ba? Actually, bumabalik lahat. Pero ang sabi natin sa obligation natin, there is delay if there is demand. Di ba? There is delay if there is demand. Okay, I hope you can recall that in your obligations and contracts. Pero ang sinasabi niya dito, when there is delay in the delivery, it is the party in fault who shall bear the risk. So, regardless of ownership, kahit na kanino yung thing na i-deliver, or kahit pa na-deliver na yung thing sa buyer kung na-delay si seller, okay, then the seller will bear the risk because of this provision in the law. Okay? Sabi nga natin, whoever has the beneficial interest should bear the risk. Of course, you can apply that in exception number 2 and exception number 3. Okay? This one yung nasa baba, na-discuss ko na. I've incorporated in my discussion. Article 1505. Where goods are sold by a person who is not the owner thereof. So from this phrase pa lang, ang nagbenta is hindi may-ari. Okay? And who does not sell them under or with the consent of the owner. So hindi na nga siya yung may-ari, hindi siya yung owner, wala ding consent. Okay? Or hindi rin siya authorized na ibenta yung property. Okay? The buyer acquires no better title to the goods than the seller had. Okay? The buyer acquires no better title to the goods than the seller had. This is the main principle of this provision. Okay? Kapag ang nagbenta is hindi may-ari, and hindi na nga siya yung may-ari, hindi rin siya authorized, wala ding consent yung owner, the buyer will not acquire better title to the goods than the seller had. Okay, meaning a famous principle in negotiable instruments law. Negotiable instruments law is the law that amended some of the provisions here that we will discuss later. Okay, ang principle under negotiable instruments law, the water cannot rise above its source. Diba? The water cannot rise above its source. Meaning, kung ano lang yung kakayahan nung nagbenta, yun lang yung kaya niyang i-transfer. Okay? Since hindi siya yung may-owner, since hindi siya yung may-ari, hindi rin siya authorized, wala ding consent, then therefore, the buyer will not acquire a better right than the seller. Not the owner, the seller. Kasi ang seller dito is not the owner and not the party authorized or with consent. The water cannot rise above its source. Let's say, for example, you have two let's say, for example, drum ito. Drum. Hindi ko alam mag-drawing. And itong drum na itong nasa right side ko is full, mayroong water. Okay? If we transfer this water to this drum, which is of the same size as this one, okay, the water will still be the same. It cannot rise above its source. Kumbaga, you cannot gain better rights. Yung sinasabi natin na principle is, you cannot acquire better rights. Magkano? Ito lang.
346.
Wala. The water cannot rise above its source. That's the explanation of the concept. That's the general rule, however. There is an exception. Unless the owner of the goods is by his conduct precluded from denying the seller's authority to sell. Okay? This is the first exemption. Okay? The owner of the goods is by his conduct precluded from denying the seller's authority to sell. Like for example, nakita ni owner na binenta ng taong walang authority yung property or yung transaction na nangyari, pero walang ginawa si owner. Okay? Then therefore, the owner is precluded from denying the seller's authority to sell. Because right then and there, when he had the opportunity to say, no, hindi ko binibenta yan, he could have said it, but wala siyang ginawa. Okay? That is implied. Okay? Kumbaga sa rules on evidence or the law on evidence, okay? That is admission by silence. Admission by silence. Meaning, You could have said something that time, or you could have done something that time, but you did not do anything. Okay, that is admission by silence. Okay, so by his conduct, he is precluded from denying the seller's authority to sell because he did not assert his right as the owner of the goods. Siyempre, kung ikaw naman, nakita mo na binibenta yung baka mo, o yung baboy mo, o yung kambing mo at wala kang ginawa, di ba, common sense will tell you na by that mere inaction, you are authorizing that person to sell that whatever it is na pagmamayari mo. Okay? And the rest are all the other exceptions. Okay? The provisions of any Factors Act, recording laws, or any other provision of law enabling the apparent owner of goods to dispose of them as he were the true owner thereof. If there are laws enabling the one who disposed of them or the one who sold them, even though he is not the owner thereof, then there could be a transfer of ownership. Okay. The second, the validity of any contract of sale under statutory power of sale. The validity of any contract of sale under statutory power of sale or under the order of a court competent jurisdiction. Of course, if that sale, kahit walang consent ng owner, let's say for example in an auction sale or in an execution sale, okay, you don't need the consent of the owner kasi nga yung owner na yan debtor. Okay, kaya nga may auction sale, kaya nga may executory sale. Okay, and there's an order of a court directing the conduct of that sale. Okay, so title may pass still. Okay, purchases made in merchant stores or in fairs or markets in accordance with the Code of Commerce and special laws, especially the anti-fencing law. Okay, we'll discuss that more later kasi may isang slide pa talking about that one. Okay. Article 1506, where the seller of goods has a voidable title. I have discussed, I can recall na sinabi ko na rin ito sa inyo yung meaning ng voidable title. There are two, but his title has not been avoided at the time of the sale. The buyer acquires a good title to the goods provided that he buys them in good faith for value and without notice of the seller's defect of title. Okay, so let's recap. Where the seller of goods has a voidable title. When we say voidable title, diba? I have discussed this before. The title is valid until annulled, diba? The title is valid until annulled. Or annulled meaning avoided or declared void ab initio. Okay? So, kung hindi siya na-annul or hindi siya na-avoid, then it is still valid. Yun yung ibig nating sabihin. And yan din yung sinasabi ni law. Okay? Sabi niya, but this title has not been avoided at the time of the sale. Therefore, the buyer will acquire good title, provided it is bought in good faith for value and without notice of the seller's defect of title. Okay? So, very simple itong article na to. Okay? The reason behind the law, before avoidable contract is annulled, I've discussed this one. One of the two innocent parties must suffer. He who placed the offender in a position to do wrong must suffer. Okay? Purchase from a thief. The true owner can get back the object without reimbursement. Without reimbursement. This one is also enforced under the anti-fencing law. Okay? But if buyer acquired object at a public auction, even if he is in good faith, the owner can still get it from him. but now he is entitled to reimbursement because of the debtor's right or the owner's right to reimbursement or to redemption. Yung sinasabi natin noon na right of redemption. He can redeem the property sold at auction. Di ba yung sabi natin before? Within 1 year. Okay, so that is Article 1506. Kung hindi pa naman na-declare na void or hindi pa naman na-annul yung title niya, pwede pang ibenta ni seller. Yun ang sinasabi niya. And yung pagbenta na yun, valid, okay, provided na it is bought in good faith for value and without notice of seller's defect of title. Sir, bakit pa sasabihin na good faith for value and without notice of the seller's defect of title kung valid pa naman? There are cases kasi na because he is aware that because the seller is aware that that his title might be voided, ang gagawin niya, ibebenta niya yan sa kakilala niya or sa friend niya na pwede niyang bilhin later on. Therefore, you cannot establish good faith there. There is bad faith there kung ganun. Okay? Kaya nga, basta ang bibili sa buyer in good faith for value without notice of seller's defect of title. If the buyer knows of the defect of title and the buyer knows that at any second that title might be annulled or might be voided, okay, and mamadaliin niya ngayong bilhin yan, that is already in bad faith. Okay? That is Article 1506. Then, di mo rin maiwasan na nag-execute lang sila ng deed of sale, but there is really no consideration or it is not sold for value. Okay? Kaya dapat for value din siya. Hindi ibig sabihin na may value doon sa deed of sale, but meron talagang consideration na tinatawag. Okay? Meron talagang pera, nag-abutan talaga. Okay? Article 1507. A document of title in which it is stated that the goods referred therein will be delivered to the bearer or to the order of any person named in such document is a negotiable document of title. Okay? Actually, yung ibang paragraphs na is covered na rin ng, yung ibang articles is covered na rin ng negotiable instruments law. Dito na, starting na from this article, covered na siya ng negotiable instruments law. Okay, why? Because negotiable instruments law covers negotiable document of titles. Okay, I will discuss later on negotiable instruments law, pero pahapyaw kasi hindi yan ang subject natin. Okay, nagkataon lang na under the obligations of the vendor, some of the articles are already amended, some are already repealed by the negotiable instruments law. Some articles are similar, actually, from negotiable instruments law. Okay? Kung ano yung negotiable instruments law, yan yung law na nagko-cover sa checks. Okay? Aside, hindi sa checks na sa bouncing, kasi iba yung anti-bouncing checks law. Okay? It talks about the negotiation of checks. Okay? Or promissory notes. Diba? Okay? Ang negotiable document of title, sabi niya, when it states that the goods will be delivered to the bearer, kapag sinabi nating bearer, from the word itself, bear, kung sino yung may hawak. Diba? One who is in possession. Meaning, if I hold the negotiable document, okay, then sa akin mo i-deliver yung goods. Ganun yung to be delivered to the bearer or payable to the bearer or to be delivered to the bearer. Sa akin mo ibibigay yung goods. Okay? Or to the order of any person, kung nakalagay doon kung sino, to the order of Mr. Lingan, to the order of of A, B, C, gano'n. Doon mo i-deliver. Kapag gano'n, sa kanya mo lang i-deliver kasi nakapangalan sa kanya. Okay, kung bearer naman, kahit kanino, basta siya yung may hawak dun sa negotiable document of title. Okay, I hope that's clear. Para hindi kayo malito sa bearer tsaka sa order. Okay, bearer, siya yung may possession. Okay. Ano yung document of title na sinasabi natin dito? Madami, actually. Okay, we have the bill of lading. The bill of lading is the evidence of receipt issued by common carrier. Okay, this is a document issued by those engaged in transporting goods. Okay, showing proof na nasa kanila yung goods in transit. Dock warrant, interim document issued by maritime carrier at the dock. Kedan, warehouse receipt that covers sugar, a warehouse receipt or a warehouse order, and any other document used as a proof of possession or as authority to transfer the goods represented by the document. Okay? It's very important kasi hindi naman lahat ng sale transaction, especially nowadays, is will only involve two parties, di ba? Usually, the sale itself involves primarily the buyer and the seller. Pero minsan, meron kang ini-engage na common carrier to deliver the goods. Di ba? Whether by land, by air, or by water. Okay? A mere typographical or grammatical error does not destroy the negotiability of a document for what should be considered is the intent. Okay? Moreover, a mere incorrectness in the description of the goods where there can be no doubt of the goods referred to will not destroy the negotiability of the document. We're talking about negotiability of the document here more. Pero ang may cover niyan is the negotiable instruments law. What we will focus on is Article 1507. Okay? So it only describes a document of title and to whom this document of title can be delivered to. It can be delivered to the bearer or to the order of any person named in such document. Okay? 1508, a negotiable document of title may be negotiated by delivery. Okay? Kapag sinabi ng delivery, from the word itself, from the general meaning of the word itself, delivery. Okay? Whereby the terms of the document, the carrier, the warehouseman, or other bailee issuing the same undertakes to deliver the goods to the bearer. Sabi ko kanina, bearer meaning siya yung may hawak ng negotiable document of title. So kung sino yung may hawak, sa kanya i-deliver ni carrier or ni warehouseman. Okay? Whereby the terms of the document, the carrier, warehouseman, or other bailee issuing the same undertakes to deliver the goods to the order of specified person, in such person or a subsequent endorsee of the document as endorsed it in blank, or to the bearer or to the bearer. Okay, wala na yan. When we talk about, we will describe endorsement later. Okay, but when we talk about negotiable document of title, this one is actually covered na lahat to ng NIL or negotiable instruments law. But we will discuss this one for purposes of understanding the article only. Okay. So it can be delivered by delivery. It can be negotiated by delivery. Paano yung sinasabi natin negotiated, attorney? Kanina pa yan. Ano ba yan? Ano ba ang term na negotiation? Okay, under sales. Okay? Kapag sinabi mong negotiated under the civil code and also under the negotiable instruments law, is when you issue this negotiable document of title in another transaction through the form of money. Okay. Kaya nabuo ang negotiable instruments law because there are documents that may be considered to be as liquid as cash. Diba? Cash are liquid assets, diba? Kasi ang just like a check or a guaranteed check, okay, that may operate as a cash kasi sure na merong pera or sure na hindi yan made-deny ni bank. Okay, they negotiate that. Hindi transfer, hindi assign, negotiate. Meaning there is another transaction. Let's say for example, naka-receive ako ng negotiable document of title. I can engage into a transaction. Let's say for example, I bought a certain number of goods from Mr. A. I can give as payment of that goods the negotiable document of title na, hindi na pera. Because they are considered as liquid as cash. Ganun ba? Ganun yung negotiable instruments law. Okay? I have a definition of a negotiable instrument later. Discuss natin yan. When we talk about endorsement naman, sabi ko kanina, discuss natin later, pero discuss ko na ngayon kasi nandito naman na tayo. Endorsement could be in blank or through, with the name of the endorsee. Okay? Kapag in blank, ibig sabihin, sinign lang. Okay? Sinign lang. Wala siyang sinabing deliver to the order of or of Mr. A or deliver to the order of or deliver to the bearer. Yun yung kung sign lang nakita nyo, blank endorsement yan. Okay, kapag itong merong deliver to the order of or deliver to bearer, ganyan. Kapag bearer, payable to bearer. Kapag to deliver to the order of, payable to order. Okay, we'll discuss this more later. Pero yan ang endorsement. Parang pipirmahan mo bago mo ibigay yung negotiable document of title. Okay. Whereby the terms of negotiable document of title, the goods are, ayan pala yun. Ito na pala yung din-discuss ko. Okay, kanina. So take note, ang negotiable document of title is para siyang under the commercial law. Okay, para siyang cash. Okay, na pinangbabayad sa mga transactions. Kaya siya negotiable document of title. Pwede mo siyang pang-negotiate, pang-bayad. Okay. Hindi yan transfer, hindi rin yan assignment. We will discuss the difference of those later. 1509, a negotiable document of title may be negotiated by the endorsement of the person to whose order the goods are with the terms of the document deliverable. Okay? First sentence, okay, sino ang pwede mag-negotiate? Siyempre, yung tao kung kanino deliverable yung goods. Either kung nakapangalagay dyan kay Mr. A or to bearer. Huwag na kayo malito sa bearer, Paul. Nasabi ko na ito kanina kung sino yung in possession of the document. Okay? Kahit sino yan. Basta nasa kanya yung document, siya yung bearer. Sa kanya mo i-deliver. Okay? Ganun yun. Okay? I hope that's clear sa bearer. Such endorsement may be in blank. Yung sabi ko kanina, in blank. Signature lang. Di ba? To bearer. Kapag to bearer, ito. Deliver to bearer. Ibig sabihin, kung nakanina yung document, dun mo i-deliver. Or to a specified person. Ayan. Deliver to Mr. Y. Ganyan. Ayan. So, there are three kinds of endorsement under this article. Okay. If endorsed to a specific person, it may be again negotiated by the endorsement of such person, either in blank to bearer to another person. Subsequent negotiations may be made in like manner. Okay? para mas clear itong sentence number 3. Ang sabi niya daw, let's say for example, si A, okay? Let's say for example, sa kanya nag-originate. Si A, pwede niyang i-endorse into 3 ways, di ba? We have discussed this. Blank endorsement or yung sign lang, or the specific delivered to Mr. Y. Sabihin mo nang si Y ito. Or to bearer. Diba? To bearer. Tatlong ways kung pwede niya i-negotiate yung negotiable document of title. Si Y in return can also negotiate that in 3 ways. Okay, ganun din yung subsequent na endorsee, kahit sino pa yan. Okay? But this one is already covered by negotiable instruments law, and I think the proper law to cover this one is the negotiable instruments law. But it's just the same. The principle applied is just the same. Okay, meron lang pagkakaiba with regards to specific types of endorsement na iniba ni negotiable instruments law. But nonetheless, this is what we'll follow for this subject. Okay? What is the effect of undated endorsement? Undated endorsement is not has no effect. It is not necessary to date an endorsement because no additional protection is given thereby to a businessman. So take note, we're under the sphere of commercial law. Okay? Unti-unti tayong pumunta sa commercial law. Okay? But nonetheless, the subject is sales. It can really be covered by commercial law. Okay? So, kahit pa walang date yung endorsement, basta importante merong endorsement. Okay? If a document of title which contains an undertaking by a carrier, warehouseman, or other bailee to deliver the goods to bearer to a specified person, or the order of a specified person, or which contain words of like import, has placed upon it the words non-negotiable, not negotiable, non-negotiable, or the like, such document may nevertheless be negotiated. Okay, ang sinasabi ng Article 1510, kung may nakalagay daw sa negotiable document of title na not negotiable or non-negotiable, ang sabi niya, negotiable pa rin. Such document may nevertheless be negotiated. So kung may nakalagay dyan na non-negotiable, not negotiable, negotiable pa rin, di ba? Attorney, bakit naman nakalagay naman na dun sa document na not negotiable, non-negotiable naman na siya? Okay? Bakit kaya? Oh. Ang tanong, why? Paano? Bakit negotiable pa rin siya kahit na nakalagay na sa document not negotiable na siya or non-negotiable na siya? Okay. Under the negotiable instruments law, ayan, ito na yung definition ng negotiable instruments or formally called negotiable document of title. Ayan. Ayan na siya. Sabi niya, it must be in writing and signed by the maker or drawer, must contain an conditional promise or order to pay the sum, certain money, payable on demand or at a fixed or determinable future time, payable to order or to bearer. If itong fifth requirement, if it has a drawee, okay, the drawee must be named or otherwise indicated with reasonable certainty. Ngayon, kung meron lahat ng ito, yan yung tinatawag nating negotiable instrument or negotiable document of title. Meron lahat yan. Okay? Kung wala yung isa dito, saka mo siya tatawaging non-negotiable or not negotiable. Okay? Kung meron lahat ito dun sa document, tapos nagalagay sa taas, not negotiable or non-negotiable, is it negotiable? Yes, it is still negotiable. Kasi ang fina-follow mo, it's not what is placed in the document, but the elements of the negotiable instruments or the requirements or the requisites. Okay? Yun ang ipa-follow mo. Kaya ang sabi natin dyan, kahit pa may nakalagay dyan na not negotiable or non-negotiable, you can still negotiate it. Okay? Why? The reason of the law under this Article 1510, aside from the reason of negotiable instruments law, because these documents, this negotiable document of title, operates like a cash, di ba? They are liquid like a cash. Kaya guaranteed yung payment nila. Okay, kaya kahit sinabi mong non-negotiable, you can still negotiate that document. Aside from this reason by the negotiable instruments law. Okay? Article 1511, sana maabot natin kahit hanggang 1520 lang. A document of title which is not in such form that it can be negotiated by delivery may be transferred by the holder by delivery to a purchaser or donee. A non-negotiable document cannot be negotiated, and the endorsement of such a document gives the transferee no additional right. We're talking about transfer or assignment na dito. We're not talking about negotiation under this article. Kasi ang sabi niya, it is not in such form that it can be negotiated. Therefore, it is not negotiable under this requisites. Merong isang wala or merong kulang dun sa requirements para maging negotiable yung document. Sabi niya, kahit pa non-negotiable or not negotiable, pwede niyang i-transfer or i-assign yung negotiable document of title. Hindi negotiate, ha? I-discuss natin yung difference nilang dalawa later on. Yun ang sabi niya under this article. Okay, but sabi niya, the endorsement of such a document gives the transferee no additional right. Under transfer or assignment, ang napapasa lang sa transferee or assignee is the title. Okay? Let's say for example, yung example natin kanina si A at si Y. Okay? Negotiate, hindi na negotiation to, tinransfer or inassign niya yung negotiable documents kay Y. Si Y, may right siya as far as the title is concerned. Okay? Therefore, pwede siya yung mag-receive ng goods. Pero hindi niya pwedeng i-negotiate na yung negotiable document of title. Why? Because he is only a transferee or an assignee. Pero kapag ni-negotiate yan, okay, gaya ng example natin kanina, si Y, ito hindi niya na pwedeng gawin. Si Y, pwede niyang i-negotiate kahit kaninong endorsee. O kahit ilan pa yan. Kahit magpasa-pasa yan. Pero dito kasi sa transfer or assignee, yung si Y, na basta yung transferee o yung assignee, hindi niya na pwedeng i-negotiate. Okay? Ang meron lang sa kanya is title. But, meron pang katuloyan na itutuloy natin later. Okay? Yan pa lang muna para ma-decipher nyo yung difference between transfer and assignment from negotiation. Okay? 1512, a negotiable document of title may be negotiated. So we can negotiate the owner, of course, or by any person to whom the possession or custody of the document, meaning kung bearer yung document, or kung to the order of Mr. Y, kung si Mr. Y yung yung nandun nakalagay sa document, then si Mr. Y yung pwedeng mag-deliver. Or of the document has been addressed by the owner, if by the Bailey is issuing delivery goods person to whom the possession person the document has been entrusted. Okay, so either to the owner or to any person who has possession or custody of the document. Who bears the loss in case of unauthorized negotiation? If the trustee betrays the trust and negotiates the document in good faith, the real owner cannot impugn the validity of the negotiation. As between two innocent persons, he who made the loss possible should bear the loss without prejudice to the right to recover from the wrongdoer. Ibig sabihin, if there is an unauthorized negotiation between A and Y, okay, and Y purchased the goods in good faith, okay, therefore Y will not bear the loss. Hindi siya yung magbe-bear ng loss. It is A who is not the innocent person because of the unauthorized negotiation that will bear the loss. Okay? But take note, a negotiable document of title may only be negotiated by the owner or by any person to whom the possession or custody of the document has been entrusted by the owner. Okay? So, pwedeng hindi yung may-ari mismo. Okay? Kaya ang sabi ko, kahit sino pa yung may hawak, if ang nakalagay sa document is delivered to bearer, okay, ibig sabihin, kung sino yung may hawak, sa kanya mo i-deliver. A person to whom a negotiable document of title has been duly negotiated. Ayan na. Okay? Ito na yung negotiation. Okay? Kapag duly negotiated yung negotiable document, ano ang ma-acquire ng endorsee? Endorsee, meaning yung ninegotiatan mo, si Y. Okay? Or yung currently na may hawak ng document. Ano ang ma-acquire niya? First is, he acquires title to the goods. Okay, he acquires title to the goods. The second one is, he also acquires the obligation of the bailee, which is to hold possession of the goods for him according to the terms of the document. Okay? So, there are two rights acquired by virtue of negotiation. The title and the obligation of the bailee, which is to hold the possession of the goods for him according to the terms of the document. Okay? Kapag transfer lang yan or assignment, sabi ko kanina, title lang yan. Pero meron pang pwedeng gawin yung transferee or assignee. A person whom the document of title, ito na pala yun, sinasabi ko, na pwedeng gawin ni transferee or assignee. A person to whom a document of title has been transferred but not negotiated. So there is the difference. Na-transfer pero hindi negotiated. Therefore, to explain better, pag transfer, meron kang transferor, yung nag-transfer, tsaka yung transferee. Siya yung nakatanggap. Kapag assignment, assignor, assignee. Okay? Ang na-acquire ng person to whom the document has been transferred is the title, as I have said kanina. Title to the goods. Yun lang. Generally, yun lang. Okay? But, if the document is non-negotiable, such person also acquires the right to notify the bailee who issued the document of the transfer thereof. Ibig sabihin, si transferee, pwede niyang i-notify yung bailee. Okay? O yung nag-issue ng document of title. Ganito kasi yan. Itong document of title in-issue ng bailee, di ba? We have discussed the meaning of document of title kanina. Should by a common carrier, a warehouseman, or other bailee. Okay? Ang ginagawa nila is they are to deliver the goods kung kanino nakapangalan or kung kanino dapat i-deliver yung goods. Okay? Ngayon, itong si bailee, binibigay niya yan dun sa, let's say for example, to the buyer. Okay? Itong si buyer, i-negotiate niya yan sa ibang parties. Let's say si Y. Si Y, ninegotiate niya kay X, ninegotiate niya kay Z. Okay? Kung itong si Z, tin-transfer niya lang kay A, si A, ang makuha niya lang is title. The right to the title. Okay? Of the goods. So, siya na yung may-ari. But, he can also notify the bailee na tin-transfer lang sa kanya yung goods. And, if he will notify the bailee of the transfer of the goods, the transferee acquires the direct obligation to hold possession of the goods for him according to the terms of the document. So, naging parehas na siya sa negotiation na ang na-acquire kapag negotiation is the title and to hold the goods. Kapag transferee, title lang. Pero kapag ni-notify niya si bailee with regards to the transfer to him of the document of title, then therefore, he also acquires the right to hold the title. Okay? Ay, to hold the possession of the goods. Okay? I hope that's clear. Prior to the notification to such bailee by the transfer or transferee of a non-negotiable document of title, the title of the transferee to the goods and the right, ito na yung, the right to acquire the obligation of such bailee may be defeated by the levy of an attachment of execution upon the goods by a creditor of the transferor or by a notification to such bailee by the transferor or a subsequent purchaser from the transferor of a subsequent sale of the goods by the transferor. Meaning, itong right ni transferee may be defeated, okay, may be defeated through levy or attachment. Ano to levy or attachment? Levy or attachment, this is a court order. Okay, nag-file ka ng petition sa court na i-levy or i-attach yung goods. Okay, yan yung levy or attachments. Okay? Na para kunin yung goods. Or, pwede naman, i-notify ni transferor si bailee. Okay? Or a subsequent purchaser from the transferor of a subsequent sale of the goods by the transferor. If merong subsequent purchaser si transferor. Of course, provided that the buyer must be in good faith in all instances. Okay? Yan na nga, yung sabi natin kanina, Article 1514 speaks of the right of a transferee. Ang na-acquire niya is the right to the title. But if he notifies the bailee, then he can exercise the right to hold the possession of the goods. Who can defeat the rights of a transferee? As I have discussed kanina, through levy, attachment, or execution. Okay, this is a court order allowing the petitioner or whoever requests for the levy or the attachment of a property to acquire the property legally, okay, or by notification to such a bailee or subsequent purchaser from the transferor, from the transferor. Okay. Article 1515, tapusin na natin to hanggang 1520. Where a negotiable document of title is transferred for value. Take note, ang word na ginamit niya is transferred, hindi negotiated. Okay, it is transferred for value by delivery, and the endorsement of the transfer is essential for negotiation. Di ba ang sabi natin kanina, if you are still with me, there are two ways of negotiating. Either you deliver it or endorsement plus delivery. There are instances under the negotiable instruments law, okay, wherein you have to endorse the document. You have to endorse the document and not just deliver the document. Dapat may signature or nakalagay doon kung kanino i-deliver yung document. Ngayon, ang sabi niya dito, under 1515, if na transfer, okay, transfer and negotiation, yung goods for value, there is delivery, but there is no endorsement. Pero ang sabi niya, endorsement is essential for negotiation. Dapat kailangan yung endorsement pero walang endorsement na nangyari. The transferee acquires the right against the transferor to compel him to endorse the document unless a contrary intention appears. The negotiation shall take effect as of the time when the endorsement is actually made. So meaning, if tinransfer yung negotiable document of title, okay, kay transferee, by delivery, na kailangan sana ng endorsement pero walang endorsement, si transferee, pwede niyang i-compel. Take note of the word. Compel. Pilitin. You can compel. Pilitin. Paano ang compel in terms of the law? You compel it or you compel the party through a court order. Diba? Mag-file ka ng case para ma-compel mo yung party to endorse the document. Why are you doing that? For that transaction, for that transfer transaction to become a negotiation. Okay? Para maging negotiation siya. But this will depend upon the intention of the parties. Kasi considering the facts or the different facts of different cases, there are cases wherein ang gusto lang ng dalawang parties is to transfer lang talaga. If that is the case, then let it be na transfer lang. But there are also instances wherein ang ginawa lang is transfer, pero ang intention nila is to negotiate. Then you apply Article 1515 of the Civil Code of the Philippines. Okay? The important thing is to consider the intention. Okay? Yan ang importante. under the civil code or under the sales, under this article. Okay? The intention of the parties. Actually, itong intention na to is very important kasi kahit ano pang contract ang firmahan mo, okay, the intention is what matters. Let's say, for example, may pinapirma sa yung document. Akala mo, pagbibenta lang ng portion ng lupa mo, pero ang binenta pala is yung buong lupa mo, hindi na portion. Okay? Kahit pa meron signed na deed of sale, pag dumating yan sa korte, ang titignan ng court is the intention of the parties. Okay, madaling sabihin yan. Okay, because we are in the academy. Pero when you go to practice or when you put that in play, before you say something in court, you must have evidence. Diba? Kaya nasabi natin before, what you can prove in court is different from the truth. There's what we call legal truth. And there's what we call the ultimate truth or yung talagang totoong nangyari. And most of the time, it's very hard to acquire evidences. Okay, let's say for example, napakasimple, mayroong sale na nangyari sa inyong dalawa. Pag dadalhin mo yan sa court, how can you say that there is a sale between you two? Ang anong kailangan mo na document? The deed of sale or the contract. Diba? If you don't have the contract, how can you say na mayroong sale? Ganun siya. Kaya sa academe or kapag nagtuturo, nag-aaral ka, madali i-apply kasi nga you're just applying the principles. But when you go to practice or when you try to do it in court, you cannot just say that there is a sale if there is no basis that there is really a sale. Okay? Kaya ganun. Kaya meron tayong under the law. Okay, meron tayong tinatawag na allegations. Ina-allege mo lang, sinasabi mo lang. Meron tayong mga claims. Kine-claim mo lang, pero wala kang basis. Sinabi mo may sale, wala ka naman may ipakitang document. Di ba? Karamihan sa parents nyo or siguro sa parents namin or sa parents ng parents namin before na ang transaction kasi before is really oral lang or verbal. Okay, ngayon lang nagiging na-realize ng tao yung importance ng document. Pero dapat in everything that you do, there is a document. Why? Because as a protection for yourself later on, kung magkasuhan or mayroong nangyari na hindi maganda, you have your protection. You can prove it in court. Diba? Ganun siya. Okay? Article 15:16. A person who for value negotiates or transfers. So it talks about negotiation and transfer of a document of title by endorsement or delivery, including one who assigns. So it talks about not just negotiation, but transfer and assignment. For value, a claim secured by a document of title, unless a contrary intention appears, warrants. Take note, for the purposes of study, ito ang didiscuss natin. Okay? Pero I believe this article has been amended, if not repealed, by negotiable instruments law. Pero some of these warranties can still be found in negotiable instruments law. Like what? The first one, the document is genuine. And then, meron din yan sa negotiable instruments law. When you negotiate or when you transfer or when you assign for value a document of title, you are warranting or you are guaranteeing that that document is genuine. Okay. You are also guaranteeing that you have the legal right to negotiate or to transfer. that thing. Okay? That you also have knowledge of no fact which would impair the validity or worth of the document. Meaning, you are guaranteeing that that document is a valid document. There is no impairment in that document. And lastly, you are guaranteeing that you have the right to transfer the title to the goods and the goods are merchantable. Or when we say merchantable, they can be transferred or sold or resold. Okay? You have the right to transfer. Di ba sabi nga kanina, the water cannot rise above its source. Di ba? Kung wala kang title or you don't have the right to transfer the goods, then the party acquiring that goods doesn't also have the right of title to the goods. Kasi nga ikaw, wala kang title or ownership sa goods, wala kang right to transfer. Therefore, yung transfer is invalid. So these four are the warranties by a person who negotiates, transfers, or assigns the document of title. Okay? We'll discuss ko na to in this one also. The endorsement of a document of title shall not make the endorser liable for any failure on the part of the bailee who issued the document or previous endorsers thereof to fulfill their respective obligations. Meaning, let's say for example, gaya ng example natin noon from the bailee, so let's say for example, B, C, to D. Say for example, D endorses the document or negotiates the document to E. Okay? If the bailee, itong si bailee daw, failed on his obligation, hindi maging liable si endorser. Okay? Or, kung itong previous endorsers, they failed on their part. Hello? Sino yun? They failed on their part. Then therefore, hindi rin pwede maging liable si endorser. Why? Because hindi siya kasama dun sa warranties under the civil code. Ang winawarat lang niya, genuine yan, meron siyang legal right, wala siyang alam dun sa impairment, and meron siyang right to transfer. Okay? Hindi kasali yung failure to perform by the bailee or failure of the previous endorsers to perform their obligations. Hindi kasali yun. Kaya hindi siya maging liable. Okay? But for the purposes of negotiable instruments law, hindi ganun yung principle. Binago na. Okay? The validity of the negotiation of a negotiable document of title is not impaired by the fact that the negotiation was a breach of duty on the part of the person making the negotiation or by the fact that the owner of the document was deprived of the possession of the same by loss, theft, fraud, accident, mistake, duress, or conversion. Just like in the previous article kanina na sinabi natin na it will not affect or the endorser will not be liable. Okay, when there is a breach of duty on the part of the person making the negotiation, or the fact that the owner of the document lost the goods by loss, theft, fraud, accident, mistake, duress, or conversion, the negotiation will still remain to be valid. It will not be affected by those scenarios. Okay, provided, of course, that the buyer is in good faith. Of course, always in good faith. Okay, meaning, Paano mo masabi na in good faith ang isang tao if he has no knowledge? Paano no knowledge, attorney? Walang alam. Hindi. No knowledge of the fraud, accident, mistake, duress, or conversion, or he has no knowledge of the breach of duty. Okay? Yun yung sinasabi natin in good faith. Hindi niya alam yung nangyari before. Wala siyang kaalam-alam. Wala siyang kamuwang-muwang. Ang nasa kanya lang, binili niya yung goods. Okay? Wala siyang alam na mayroong parang defect yan. Kasi kung alam niya yan, hindi niya sana binili. May mga ganun na instances. Okay. 1519, if goods are delivered to a bailee by the owner or by a person whose act in conveying the title to them to a purchaser in good faith for value would bind the owner and a negotiable document of title is issued for them, they cannot thereafter, while in possession of such bailee, be attached by garnishment or otherwise be levied under an execution unless the document be surrendered to the bailee or its negotiation enjoined. There are two rules that we speak of. Of course, the general rule that the goods cannot be attached or levied, okay, except if the document is surrendered to the bailee or the negotiation is enjoined. And the second one, the bailee cannot be compelled to surrender the goods, except if it is surrendered to him or impounded or ordered by the court. Okay. So that is Article 1519. So kaya. 1520, last for tonight. A creditor whose debtor is the owner of a negotiable document of title shall be entitled to such aid from courts of appropriate jurisdiction by injunction and otherwise in attaching such document or in satisfying the claims by means thereof as allowed by law in equity in regard to property which cannot readily be attached or levied by ordinary legal purposes. Meaning, binanggit niya si creditor, si debtor. Si debtor daw, debtor nitong si creditor is the owner of a negotiable document of title. Since creditor siya, may pautang siya kay debtor. Okay. To secure his credit, di ba, yung pinautang niya kay debtor, he is entitled to such aid by the court in collecting the debt of the debtor, yung mga utang ni debtor, either through injunction or in attaching the document or the negotiable document of title or in satisfying the claim. Of course, madaming remedies si creditor to collect the debt of debtor. Diba? Yung ilang dyan, nabanggit niya na injunction, attachment or levy, or satisfy the claim by filing a collection case. Tawag niya sa court, collection of sum of money. Or, kung sakali na i-negotiate to ni debtor, you can ask for injunction para hindi ituloy yung negotiation. How is protection made? Judgments not easily made, they are entitled to such aid from courts by injunction and otherwise in attaching such document. Of course, because the document or the negotiable document of title, okay, is a commitment from the bailee that the bailee will deliver the goods to either the bearer or to the person specified under that negotiable document of title. Siyempre, ikaw naman na creditor, kung aware ka na si debtor ay owner ng negotiable document of title, Therefore, isa yun sa pwede mong habulin. Di ba? Kung ikaw yung creditor na tinataguan ka na ng taong pinagutangan mo, gagawin mo lahat para makakolekta. Okay? And the courts should help you in collecting in collecting the debt of the debtor. Okay? So hanggang dito lang muna tayo sa 1520. I hope for the next meeting we can finish the whole chapter of the obligations of the vendor, pero madami pa. Madami ata itong obligations of the vendor. But I hope we can finish that para madami-dami kayong coverage sa exam. Okay? With regards to quizzes, wait lang, check yung calendar. Siguro we can have another meeting before tayo mag-quiz. Okay, so the quiz will be departmentalized as before. Okay, and expect siguro case study and other activities next week. Hindi muna ngayong week, so next week. Questions?
Sir, ano yung magiging coverage po ng quiz?
Hanggang dun sa matapos natin next meeting.
Yun din yung coverage na rin po ng exam, sir.
Yeah, oo. So para ready kayo sa exam.
Thank you, sir.
Pero hindi siya parehas. So magkaiba siya. Okay? So para diretso na sa exam. Kailan ang exam nyo? First week ba? Or
Yes, sir. First week of April, sir.
hindi naman 5? Hindi ba 5? Hello? Hello?
April 4 to 6
Hindi
ata,
po,
sir.
sir.
4 to 6?
Yes, sir. Pero yung ano, sir, yung loss po, sir, is second day. So, I think April 5 po, sir.
Online to? Online ba itong exam?
Yes, sir. Wala pa po kasing official
Wala siya.
Wala pa pong official na announcement, sir, kung ano po yung mode po ng exam po. Kasi may mga nagsasabi po na face-to-face, pero hintayin na lang po namin kung ano po yung sasabihin po ng admin.
Sige, please inform me if meron. Oo, para alam ko din. So,
Sige
ano?
po.
Sige. Let's have a quiz next week. Kasi hindi ko alam kung maabot ito. Hindi natin maabot kung 5, 4, 5, 6. Let's have a quiz. Same day, same time. That is Tuesday, tama? 6 to 7:30, tama? Your time?
Sir.
Yes, sir.
Di ba yung dati nating quiz, departmental quiz day is Tuesday? 6 to 7:30, tama? Hello?
Yes, sir. Sir, pero ano po yung target po natin
So,
na...
the coverage of the quiz is from the start hanggang dito lang muna sa 1520.
Yes, sir.
Okay? But I will try to release na may cover natin hanggang or matapos ko yung obligations of the vendor. Siguro mag-send ako ng link sa inyo sa other classes kung kailan kayo maka-attend for next week kasi masagasaan yung oras nyo ng Tuesday or mag-upload din ako ng video para as an additional topic sa exam. No? Is that okay?
Yes po, sir.
Okay. Sige. That's all. Meron pang question? Wala na. So if that's all, then let's end the night. Good night, guys. Thank you for attending.
Thank you po, sir.
Sir.
Thank you,
Thank you po,
sir.
sir.
Thank you po,
Thank you,
sir.
sir. Bye, sir.
Bye-bye.